Isto velja tudi za varovanje naravne kulturne dediščine. Naj opozorim posebej še na 74. člen, to je svoboda podjetništva. Tu imamo pa zelo sistematičen in natančen prikaz ustavno-sodne presoje. Avtorica je tu pravila zelo, odlično delo. Potem spet sledi še nekaj členov, ki so na tem mestu iz področja socialne države, z istimi avtorji kot iz prvega komentarja, soodločanje, sindikalna svoboda, pravica do stavke, primerno stanovanje in v Sloveniji zaposleni tujci. In s tem je zaključen tisti del, ki se nanaša na 3. poglavje ustave in prehajamo na državno ureditev, ki se pa začne z državnim zborom. No, tu smo pokomentirali oziroma dopolnili tiste člene, ki so bili v tem pogledu najbolj pomembni za nadaljnji ustavni razvoj in pri katerih je tudi prihajalo do relevantne ustavno-sodne presoje. Kajti ustavno-sodne presoje vendarle predvsem obravnava prvo, drugo in tretje poglavje ustave, ki je govora o človekovih pravicah in temeljnih svoboščinah. V takej drugačni obliki. Seveda ustavno sodišče odloča tudi o drugih ustavnih pravicah, iz kateregakoli ustavnega člena, to je razumljivo. Zato je komentar tudi ustavnega sodišča, ustavno-sodna presoja se tudi opravlja kot odločeno, vendar bolj poredko. Tu smo zato, kot rečeno, naredili dopolnili najprej 43. člen za 80. členom in tudi 81. členom ustave, ki govori o državnem zboru, o volitvah v državni zbor. Tu smo uspeli pridobiti dva nova avtorja, ki sta v tem pogledu izjavila tehtno analizo. Pri nekaterih posameznih členah smo pa, kar z veseljem ugotavljamo, smo pa lahko dobili tudi nekaj mlajših pravnikov, ki se ukvarjajo s posameznimi vprašanji iz področja državne ureditve in ki so v tem pogledu prispevali zelo tehtne komentarje, recimo v 86. členu ali v 87. členu ustave. Potem je prav, da povem, da je tudi temeljito dopolnjeno oziroma praktično skoraj na novo napisano poglavje o predsedniku republike, kjer imamo glavnega novega avtorja z nekaj malega sodelujočih drugih avtorjev, vendar en avtor je prav glavni komentar tega. To je gotovo tudi en tehten nov pogled. Potem prehajamo na področje uprave. Pri področju uprave je upravljena temeljita dopolnitev drugega odstavka 120. člena uprave. Zakaj posebej poudarjamo na ta drugi odstavek 120. člena in zakaj je vreden tako tehtnega vpogleda? Zato, ker ta odstavek seveda določa in postavlja legalitetno načelo pri delovanju upravnih organov, eno bistvenih načel tudi za delitev oblasti in za delitev oblasti. Zato je bilo prav z tega področja najti zelo veliko primerov ustavno-sodne presoje. Najpomembnejši ti primeri so prikazani potem v dopolnitvi komentarja. In zdaj spet 121. povsem na novo napisan člen izpod presa istega avtorja, kot v prvem komentarju. Na novo napisan pa zato, to gre za javno pooblastilo, ker se je seveda med tem ustavna dikcija v tem členu spremenila. Potem najdemo potrebne dopolnitve nekoliko manjšega obsega, ki so bile podane pri poglavju pod sodstvom in državnimi tožilci. In prejdemo na praktično skoraj da na novo napisano poglavje o lokalni samoupravi, ki je seveda moralo biti napisano na novo, ker se je medtem spremenil ustavni člen, ki je urejal položaj lokalne samouprave v Sloveniji, je pa izpod peresa istega avtorja. Potem še nek ustavno-pravni pogled na 149. člen, kreditiranje v breme države, tudi smo pridobili novega avtorja, dopolnitve po računskem sodišču izpod peresa istega avtorja. Potem imamo v nadaljnjih členih ustavnosti in zakonitosti, predvsem dopolnitve od 153. člena naprej. Gre za usklajenost pravnih aktov, za veljavnost predpisov, njihova objava, za prepoved retroaktivne objave, pa tudi za postopek za oceno ustavnosti in za upravni spor. In tudi pravnomočnost. Tudi imamo kar tehtne prispevke zlasti pri upravnem sporu in pravnomočnosti, ker je tem prišlo tudi do spremembe zakona, ki so pa tudi pomembne in področja. Ostane mi še da upozorim na dopolnitev 160. člena izpod peresa novega, našega avtorja, ki je pa napisal zelo kvalitetni in izjemen komentar 160. in tudi 161. člena. 160. člen govori o pristojnosti ustavnega sodišča, 161. člen pa o razveljavitvi zakona, tudi o 162. člen izpod peresa istega avtorja, ki govori o postopku pred ustavnim sodiščem. Vsi ti členi so seveda izjemnega, doktrinarnega, zlasti pa tudi praktičnega pomena. Za vse, ki želijo uveljavljati postopek pred ustavnim sodiščem, in njihova prednost je tudi ta, da v vsebinskem pogledu širom preko vsega komentarja predstavljajo posamezne oblike ustavno-sodnega varstva, pa tudi na kratko posamezne primere ustavno-sodne presoje in jih je seveda, bom rekel, nujno poznati in so ravno tako nepogrešljivi, bom dejal, za vsakega, ki hoče biti pravno zastopnik in ki hoče nekoga zastopati v postopkih pred državnim organim. Tudi tu se ne znam predstavljati nekega odvetnika, ki tako rekoč ne bi teh členov poznal, tako rekoč, da jih ne bi imel v glavi, ali pa tako, da jih lahko vsaki poišče s tem, če nekoliko, ampak zelo malo polista po komentarju ustave, ker že ve, kje je kaj. No, pa imamo še na koncu tudi izpred peresa novega, priznanega avtorja, še, bom rekel, zelo tehtno obdelan postopek za spremembo ustave. S tem je pa tudi ta moj kratek prikaz prihaja v zaključno fazo. Naj povem še, da smo se čisto na koncu med poletjem v pogojih tudi tropske vročine pa seveda najbolj ukvarjali s ostalimi deli komentarja s predstavitve avtorjev, s kraticami in okrajšavami. Žalska pri predstavitvi avtorjev sta izpadla dve predstavitvi dveh mlajših avtorjev, enega avtorja in ene avtorice, in se sam kot urednik upravičujem, da se je to zgodilo. Pri tako velikem delu se pač to tudi zgodi, so pa seveda navedeni kot avtorji vse posodne in so lahko posebej predstavljeni v tisti predstavitvi na koncu. In dejansko smo se pa takrat najbolj ukvarjali z skladnim kazalom. Stvarno kazalo je pa pravzaprav nočna mora, veste, vsakega, ki ga izdeluje. To smo srednje delali v sodelovanju z avtorji. Glavno delo je pa opravil kolega Arne Mavčič, profesor dr. Arne Mavčič, in stvarno kazalo je na ta način tudi naraslo na vseh 100 strani. Smo se pa zavestno odločili, da gre za združeno stvarno kazalo prve in druge knjige. Kajti zdelo se mi je nesmotrno, da mi nekdo iskal zadeve, ki ga zanimajo, najprej v enem, potem pa še v drugem stvarnem kazalu. Enostavno bi bila to izguba časa. Zato smo tudi v tem stvarnem kazalu, ki ga najdemo na koncu do prireditve, komentarja ostave, in ki je tudi zaradi tega narasel na vseh preko 100 strani, združili stvarno kazalo iz prve in druge publikacije, kar seveda omogoča vsakomur, ki uporablja to stvarno kazalo, da v njem najde zanesljiv kažipot, tako v prvi kot tudi v drugi knjigi. Recenzijo dela sta opravila docent dr. Matjaž Naktigal in izredni profesor dr. Marko Novak. Knjigo smo registrirali kot znanstveno monografijo. Knjigo je tudi v zelo skromnem obsegu financirala Agencija Republike Slovenije za knjigo. Kaj nekaj na koncu še? Zahvaljujem se vsem, res iskreno, vsem avtoricam in vsem avtorjem, vsem sodelavkam, vsem, ki smo sodelovali pri tem projektu. Res sem zadovoljen. Mislim, da smo lahko tudi vsi skupaj zadovoljni in prepričan sem, da bo ta komentar ostale pomembno, pa tudi nepogrešljivo dopolnitev prvih knjig. Njegovo nadaljno uporabnost bo pa seveda tako kot pri prvi pokazalo življenje. Hvala lepa.
Še enkrat hvala profesorju Šturmu za to izjemno izčrpno predstavitev komentarja Ustave Republike Slovenije. Naj se ob tem še enkrat v svojem imenu in v imenu fakultete zahvaliti vsem soavtorjem, da ste tako odlično opravili svoje delo. Pri tem pa naj dodam, in s tem bo fakulteta soglašena in spodbujala, da pravzaprav ta komentar ni konec zgodbe, ampak že predstavlja nov začetek. Z izidom dopolnitve komentarja Ustave Republike Slovenije se že lahko začne delo na novi, konsolidirani verziji, ki bo zajela sodno prakso v nastajanju. In upam, da bo tudi tedaj profesor Šturm tisti, ki nas bo preganjal pri delu. Zdaj mi podovolite, to tako se zgodi na akademskih konferencah, da se urnik nekoliko sesuje, in mi dovolite, da vam povem, kako bomo nadaljevali do konca današnjega dne. Sledila bo najprej keynote address gospoda Paula Mahovnja, ki ga bom napovedal čez nekaj trenutkov. Po tem keynote addressu bo pa že organizirano, tako kot je na urniku, kava, in po odmoru za kavo bomo o 3:30 organizirali še zadnjo okroglo mizo, ki jo bo moderiral naš kolega, prodekan, docent dr. Jernej Letnar Černič, in tedaj bomo prosili vse sodelujoče na tisti okrogli mizi, da se nam pridružijo tu v ospredju. Čisto na koncu bo predstavljena še normativna vizija fakultete za prihodnost. Po samem uradnem zaključku bi pa še alumne fakultete poprosil, da me počakajo v tej dvorani, da skupaj formaliziramo in ustanovimo tudi alumni klub, ki je sicer že obstajal, pa je nekako prenehal živeti. Tako da napolnimo fakulteto še s to vsebino. Zdaj pa mi boste dovolili, ker bom napovedal, kot rečeno, gospoda Paula Mahovnja, da naredim lingvistično zamenjavo in ga napovem v angliščini. It is my great honor today to welcome here with us Mr. Paul Mahoney as a keynote speaker. Mr. Paul Mahoney is a man of great experience he served at the European Court of Human Rights as a registrar for many years, and most recently he retired from the European Civil Service Tribunal of the European Union that he presided. Paul Mahoney is going to talk to us about a so-called European judicial mosaic. That is about the vexed relationship between the European Convention on Human Rights on the one hand and its court, and the European Court of Justice and its court. As you know, these are two different institutions with two different ambitions and purposes. And yet, the Lisbon Treaty had mandated that the European Union accedes to the European Convention of Human Rights. And this will, of course, bring about all sorts of interesting, difficult questions. And since Paul Mahoney has served in both of these institutions, he is the most appropriate person to discuss this topic with us today, and I'd like to welcome him on the floor.
Thank you. First of all, I should like to apologize for not being able to speak to you in your own language, and for being the only person today to inflict on you a contribution that is not in Slovenian. At the same time, I am honoured, very honoured, as a non-Slovenian, to have been invited to speak to you today, and also that Professor Jambrecht remembered that I was here 10 years ago when the Graduate School of Government and European Studies was launched. Professor Jambrecht asked me not to choose a subject that was too academic or scientific, but rather to say a few words about my experience on the inside of the two European courts, the European Court of Human Rights in Strasbourg and the European Court of Justice in Luxembourg, and to compare the two courts and signal any interesting differences. However, given the mission of the graduate school, I think it might be appropriate first to present in a few words the European Union Civil Service Tribunal, where I was a judge up until 2 weeks ago. In other words, I take advantage of the occasion to go in for a little piece of self-advertising. And then, secondly, I'd like to attempt a comparison of the style of the judgments delivered by the two European courts, as reflecting not only a difference of judicial culture between them, but also the different functions served by the two courts in their respective legal systems. And then thirdly, I would like to speak about the impact of the forthcoming accession of the European Union to the European Convention on Human Rights, and the impact that this accession will have on the institutional relationship between the two courts. Now, there is no logical connection whatsoever between these three topics. It's a rag bag of three separate issues, so I hope you will bear with me. Well, first of all, the Civil Service Tribunal. This is a first instance administrative court dealing with staff cases in the European Union. And that's cases brought by staff members of the institutions against their administration. It was set up in 2005. It is an integral part of the European Court of Justice, or the Court of Justice of the European Union, to give it the formal title that it has under the Lisbon Treaty. There are in fact three levels of jurisdiction within the European Court of Justice. There is the Court of Justice itself at the apex, then underneath it there is the General Court, which was formerly known as the Court of First Instance before the Lisbon Treaty, and then at the bottom of the ladder there is now the Civil Service Tribunal. In fact, civil service cases have an honoured place in European Union law first judgment in the staff case was delivered in 1955 after proceedings that lasted barely 6 months. If you look at the data bank of the decisions by the Court of Justice, you will see that there are something like 4,000 decisions on staff cases. And that is by far the largest category of cases in the data bank. And the origin of the creation of the Civil Service Tribunal was the desire to relieve the Court of First Instance, which itself had been set up in 1989, of a large part of its caseload by transferring a particular category to a lower jurisdiction. But at the same time, the Civil Service Tribunal became the first specialised court in the European Court of Justice. The other two courts are generalists in that they have to deal with an extremely wide range of legal issues under EU law. The composition of the tribunal is not the same as the other courts. They both have one judge for each member state. That's to say 27 judges. The Civil Service Tribunal only has 7 judges. The Treaty of Nice in 2003 foresaw the possibility of a series of specialised tribunals under the General Court. So it's possible, conceivable in theory, that you could have future specialised tribunals dealing with, say, competition cases or intellectual property. That, however, is unlikely. And I say this because at the moment the General Court has a chronic problem of case overload. Cases are being delayed. They are lasting 6, 7, 8 years sometimes. One has the peculiar position of a judge being nominated to the General Court with a 6-year term of office, being appointed judge rapporteur in a given case, a heavy case, but not knowing whether he or she will still be there when the judgment is finally delivered in the case, 6 or 7 years later. Well, there is, before the Council of the European Union, a proposal made by the Court of Justice to resolve this problem by creating 12 supplementary judges on the General Court. And the Court's proposal explains why the General Court's own preference, which was to have a specialised trademark tribunal set up underneath it, why this would not work. So there is a difference of opinion between the Court of Justice and the General Court as regards the future structure of the European Union judicial system in Luxembourg. That is likely to be decided soon by the Council, and it's likely that there will be an expansion of the judges of the General Court from 27 at the moment to 39. How the 12 new judges will be appointed, since there is not one for every member state, is of course another question. So it will not be the model, it seems likely that it will not be the model of the Civil Service Tribunal that will be followed. And I should explain that this is not because the Civil Service Tribunal is considered to have failed. Indeed, if you look at the statistics, you will see that the length of proceedings is considerably shorter now than it was when the General Court was dealing with staff cases at first instance. The Civil Service Tribunal has a balanced output. It disposes of pretty well the same number of cases as come in. And indeed, when I left the Civil Service Tribunal 2 weeks ago, the pending stock was the lowest that it's ever been. And the European Union Committee of the House of Lords, that's the upper parliamentary chamber in the United Kingdom, described the Civil Service Tribunal as a success story. Rather, the thinking behind the proposal of the Court of Justice is that it's the internal character of staff cases, the fact that they have no impact on the legal orders of the member states. It is that which means, which justifies the existence of a specialised tribunal, whereas other considerations militate against the creation of a specialised tribunal for trademark cases. Well, coming now to my second topic, which is the comparison of the style of judgments of the Strasbourg Court and the Luxembourg Court. The Luxembourg procedure is much stricter and much more formal, some might even say formalistic, and its judgments are much shorter and much more categorical. I would say dirigiste in French, as compared with the situation in Strasbourg. Well, the significant difference between the nature of the two legal systems, the EU system on the one hand and the European Convention system on the other, means that the judgments delivered by the courts serve rather different purposes. And in my view, this explains the difference in style between the judgments of the two courts. EU law is more directly integrated in national legal orders, preliminary rulings that national courts ask at the Luxembourg Court, for example, are binding not only on the particular court that has asked for the ruling for the purposes of those particular national proceedings, but the rulings are binding on all the national courts throughout all the 27 member states, given the exclusive mission that the European Court of Justice has for ensuring the unity of interpretation of EU law. The European Court of Justice is a kind of supreme court for an economic and now political union, having the task of fixing an authoritative, uniform meaning for the law that is applicable within that union. Also, EU law tends to be black letter detailed law on the whole, rather than the open-ended formulations that you find in the European Convention. And then, in most, all of the important cases, the judgment will have been preceded by an opinion from an Advocate General. Advocate General's opinions are comprehensive. They usually canvass all the issues that are raised by the case. And this permits the Court of Justice itself, when it comes to deliver its own judgment, to be more economical in its reasoning. The role of the European Court of Human Rights, on the other hand, is not to ensure uniformity of the application of the European Convention in the 47 contracting states. Rather, it has to assure an external, international control of democratic action at national level to see whether that national action complies with the standards of the Convention. What the Strasbourg Court has to do is to review whether the contracting state in the particular case has complied with its obligation of result under the Convention, there perhaps being a very large range of choices open to the state how it achieves that requisite result. But the mission of the Strasbourg Court is not simply to resolve particular disputes. It also involves generating a case law which states principles and values for interpreting the Convention, and in particular when national courts are having to deal with human rights issues in their legal system. If you like, it's a kind of European common law of human rights in that sense. Yet the judgments of the Strasbourg Court are binding only on the government, which is the defendant party in the particular case. They are not even binding directly on the courts of that state, and they're certainly not binding on the other states or the courts of other states. But the willingness of the national courts to apply the Convention case law that's created in Strasbourg depends on the confidence that the national judges have in the quality of the leading rulings that come out of Strasbourg. The European Court of Human Rights is therefore obliged to explain its judgments in order to obtain the adhesion of the national judges. It realizes that its judgments have a pedagogical function as well as a declarative